Welcome to the fourth and final session of this Junior Professional Legal and Regulatory Tutorial Group round. My name is Jess Morton and I work at the Global CCS Institute and I'm based in Melbourne, Australia. Even though this is the last session, I would encourage you to stay in contact with each other through the Junior Professional CCS network, and an email will be sent out in the coming week to let you know how you can connect with that group. But it is a group. There are around 80 people in the group at the moment, and it's a platform online that people use to either arrange face-to-face meetings at events, to share media releases or publications, and really just to discuss pressing issues or issues that are of interest to them in the CCS space. And as I just said, we will send information out for that group, and we can connect you through a very similar extranet platform. We've had a really great response to these sessions. Thank you all so much for your enthusiasm and for logging in each week and for your participation. So I just wanted to quickly recap what we've covered in these sessions. We had Sally Greenberg talk about public engagement and some regulatory issues with the Decatur, Illinois project in the United States. Stephen Carpenter talked about the international standards for CCS. Diana Papatuia talked about the European CCS directive and 3 different approaches that have been taken in the United Kingdom, the Netherlands and Norway. And so for today's lecture, Andrew Gilder will provide us with an overview of the status of CCS implementation in South Africa, with particular reference to the evolving policy and legal regime. As you know, Andrew's lecture will be immediately followed by a tutorial discussion, and the entire session will go for around 60 minutes. Before I begin, for the last time I'd like to introduce you to our tutors and our lecturer. Craig Hart and Pam Tomsky are both highly regarded in the CCS community. Amongst other roles, Craig is the ENN Group Associate Professor at Renmin University of China's School of Environment and Natural Resources, and he's also a lecturer at Johns Hopkins University's Energy Policy and Climate Program. Pam is the Senior Advisor, Policy and Regulatory Americas at the Global CCS Institute. Some of you may know her as part of her work either through the Atlantic Council or through the research experience in carbon sequestration program, and Pam will talk a little bit more about what's happening in the REX program at the conclusion of this session. Thank you, Craig and Pam, for leading us through these tutorials. Your insights and direction are a huge part of these sessions, and personally, thank you very much for leading these. So today's lecturer is Andrew Gilder. He is the go-to guy for all things in the CCS regulatory space in South Africa and increasingly so for Africa, and I think you'll find him a really engaging speaker. He is a Senior Associate at ENS Africa and has 14 years experience in commercial law and regulation in Europe and Africa. And he practices as an attorney in the environmental law and specializes in carbon markets, climate change law and policy, including CCS projects. His general practice experience expands over African and European jurisdictions and includes providing regulatory and transactional advice to industries, foreign embassies and municipalities on the implementation of greenhouse gas mitigation projects and programs. His experience further extends to climate change strategic guidance to businesses and advice on climate change related policy development, particularly CCS policy. I would like to encourage all of you to send questions on Andrew's lecture throughout the presentation, and Craig and Pam will compile those to ask Andrew at the end. So that is all from me. Andrew, welcome, and if you could please take over from here.
Yeah, right. Just give me a shout when it's all up and running, please. Can you see that? Right. Can I commence now? Yeah, good. Right, thank you.
Yes.
Brilliant.
Okay.
Right, so thank you for the intro, Jessica, and to all for attending, and thank you to the Institute for the opportunity to present on where we are in South Africa. The South African jurisdiction is particularly interesting from an environmental, legal, and consequently climate change CCS perspective, because a lot of the laws are very new. So just by way of illustration, if you've got the EPA in the United States as a piece of legislation dating from the early 70s, the overarching environmental statute in South Africa, which is called the National Environmental Management Act, only dates from 1998. And so a lot of the legislation is very new. A lot of the legislation in terms of which CCS projects would be implemented is very new, and consequently it makes for a very interesting and dynamic space. My marketing department has told me that I'm required to do one or two words of that advertisement. So the only thing I will say is that ENS Africa is the largest independent law firm on the African continent. So what that means is that it is remaining independent from overtures from some of the very large international firms. So the South African legal space is well populated with legal names that you will know if you're in the business, the likes of Baker McKenzie or Norton Rose Fulbright. ENS is determined, is originally a South African firm, but is determined to retain that identity. And there are offices currently in various countries around the continent, and the growth plan includes obviously to open further offices as we move on in time. Okay, enough said. Now, if I look back very briefly to the origins of CCS in South Africa, like many of these things, I suspect in a range of countries, CCS was for a long time, and to some degree still is, driven by a relatively small core group of people who are or were originally in government and now are working in parastatals. But the strong link between CCS and climate change policy development in the country really originates in a study that was concluded in 2008 but ran from 2006 to 2008, called the Long-Term Mitigation Strategy Scenarios. This strategy, as duly updated over time, is specifically informing what South Africa is doing in terms of its climate change policy development and how it presents itself in the international arena. If anybody is a climate change aficionado, you will be aware that there is a notion, a concept missing from here, which is the notion of adaptation. And we are currently in the second phase of the development of a long-term adaptation strategy for the country as well. South Africa faces a number of unique challenges on this continent, primarily the challenge that it is both a very large emitter of greenhouse gases, but is also going to be required to introduce very firm adaptation measures. So the challenges facing South Africa, slightly differently from the challenges facing a lot of the other countries on this continent, is that it needs to take action both from a mitigation and an adaptation perspective. Just allow me to clarify that. A lot of the countries on the African continent don't have very large greenhouse gas emissions profiles, and so actions to mitigate industrial scale emissions are not necessarily their main focus. Their main focus is going to be around adaptation. In the presentation, periodically I've placed hyperlinks and URLs which should take you to the particular study if you are interested. Now, CCS coming out of the long-term mitigation strategy is one of the interventions that was recommended, and so let's have a look very briefly at how that has traced over time. If you are unaware, the question is, well, why is CCS important for South Africa? So the next couple of slides literally are a couple of bar graphs that'll perhaps give a flavor of this. So there is a very high fossil fuel baseline in this country, primarily coal. This slide simply demonstrates that relative contribution of coal to the rest of the suite of power generating media, if you like. You will note that renewable energy right there on your right hand side is relatively small. It is growing, but it is certainly, of course, nothing like the predominance of coal that we see. Speaking of the predominance of coal, you're looking still at a situation where 90% of primary electricity supply in the country is generated by coal. Slowly diminishing, but still very, very much in that vicinity. And you might want to think about or ask some questions about what the potential is for South Africa to be changing its diet of coal anytime soon. And I have a view on that which I'll share with you. Unsurprisingly, given the previous information that was up, you will see that the energy sector produces the highest level of greenhouse gas emissions in the country. In fact, if we look back to the first carbon disclosure project in the country, which was 2007, the state, largely state-owned power utility, and I'm aware that the CDP targets private sector, but the state-owned power utility known as Eskom decided it wanted to participate in the CDP and in fact did so. We learned that literally 51% of the country's emissions are generated by that single entity. So that is the entity that runs all of the large-scale power stations in the country and is responsible for more than half of the country's greenhouse gas emissions. In which case then, what is the plan going forward? Do we still have plans to keep coal in that energy mix? And are there plans for future build of coal power stations? The answer to all of those is yes, without question. And this is where some debate might come into it. So if I look at just what we've got on the planning agenda as we speak, there is the Medupi power station, which is under construction. When that is commissioned, which they're anticipating in late 2015, which will be approximately 2 years delayed, that will be a 4,800 megawatt installed capacity coal-fired power station, but using supercritical technology. I mention that because if you know anything about South Africa, South African coal-generated power, you will probably know that the technology is quite old in the existing power stations. And this is the first supercritical technology power station that we will have. And then pending, we've got the Kusile power station, which will come online towards 2020, and that will be 5,400 megawatts. There are at least another 2 coal power stations that are anticipated to be built, and the question is, I suppose, where is all this coal going to come from? There is a deposit that is largely untapped in this country, notwithstanding nearly 100 years of coal-generated power. It's called the Waterberg Coal deposit. It currently represents approximately 40% of our coal reserves, 50 billion tons, and approximately 200 years of exploitation at current rates. Now, clearly, this is where the debate around renewable energy can come in, but all of this as well, to my mind, are very clear indicators. These are very clear indicators of why CCS is so important for South Africa. Might be worth also mentioning that notwithstanding the size of that Waterberg coal deposit, if you look at a geological map of that deposit and you track it under the countries of South Africa, Botswana, and Namibia, you will understand that the volume of coal that I have just described for you as pertaining to South Africa is really the tip of a very large iceberg. So the actual deposit is orders of magnitude larger than this 50 billion tons, which perhaps gives you an indication of just how difficult and challenging it is for countries with that sort of natural resource available to make decisions that will tend to avoid using that natural resource. Again, possibly something we can discuss. I'd like very briefly to point out that we have in this country already a legal obligation to implement CCS. There is the requirement for large infrastructure projects like power development, like power stations, to obtain an environmental authorization. And the environmental authorization for the Kusile power plant, which is the one which is not yet ready, not yet being built, is that it must be built carbon capture ready. Now, some of you who will be very familiar with the whole debate around what constitutes carbon capture readiness will be sensitive to the fact that is a really open-ended question and depends on a very great number of factors, not least of which what might be accepted practice within the particular jurisdiction. So although this is a legal obligation for that power station to be built carbon capture ready, it's really difficult at this point to pick apart and to understand what the detail of that obligation in fact will mean. For example, does it simply mean that sufficient space must be left adjacent to the power station so that at some time in the future a CCS plant can be built and attached to that power station? Or does it mean literally a complete redesign of the intended technical specifications of that power station, which you will appreciate will be orders of magnitude more expensive than the existing specification? So these are some of the nuances and the technical issues, legal technical issues that start coming to play when we start thinking slightly more carefully about CCS in South Africa. I'm just going to run you through a couple of milestones. So we've got a dedicated organization under the auspices of something called the South African National Energy Development Institute. That is a parastatal. It has a number of operating institutes, if you like, operating wings, one of which is this, the South African Center for Carbon Capture and Storage, or SACS. I think I've added one more C than I should have there in that web address. I'll change that before it gets sent out. So SACS is an organization funded largely by donor countries, so Annex 1 or OECD donor countries, and certain companies that have interest in the development of CCS technology in South Africa. And among its objectives are identification and characterization of sources, of sites, developing and adapting CCS technologies for South Africa. And then the reason that I do quite a lot of the CCS work that I do is one of its objectives is the issue of looking at regulatory gaps and recommendations on how these gaps should be addressed. So if you spend any time looking at how CCS is developed in other parts of the world, you will be attuned to the fact that the regulatory regime is essential for the efficient implementation of CCS projects, and also with a view to the future to some of the considerations that we might need to deal with in due course and down the line. For example, issues around long-term liability. You will be aware that the IEA has done work in this. The GCCSI is doing a lot of work in this area as well. The University College London, and among a number of organizations that are looking specifically around this issue of the regulatory regime. And from my perspective, when we start looking at the legal aspects of it, a lot of very interesting texture starts arising. One of the very first actions of the CCS Center in South Africa was to devise the Atlas on CCS in South Africa. So this is a 2010 study. It is based on a series of studies that were done over time prior to this, and the previous studies were not specifically focused on identification of CCS sequestration sites. They were general geological studies, or alternatively they were studies that were looking at oil and gas exploration. So the Atlas is the first time that we pull together all of this information to try and determine whether South Africa has a sequestration resource and where that resource might lie. And you will be interested to see that the majority of the resource lies offshore. If there are lawyers amongst you, you will realize that what that really does is simply complicate the legal considerations that one has to take into account when one is trying to figure out what is the law that applies to a particular CCS initiative. For example, if that sequestration resource, if that reservoir lies outside of the country's territorial sea, there might be legal consequences that flow. And in the South African context, there are a number of layers of legislation and regulation that apply to developmental and infrastructure projects that are undertaken in the coastal zone. So whereas you might be required to obtain simply an environmental authorization to do an infrastructure project somewhere inland in the coastal zone because it's much more sensitive as a receptive medium, as an environmental medium, there are a number of other considerations that need to be taken into account, and these lead, of course, to cost and time consequences. Last point I'd like to make about this slide is that there are two main areas that are currently being considered as the location for what is being called the pilot project. The first one is that black dot at the bottom of your screen, that is the so-called Outeniqua Basin. And then if you look to the right of your screen, there is the name of a town called Durban, which incidentally is where I originally hail from. And opposite Durban, there is a large black dot. That is the so-called Zululand Basin. So they are looking at a pilot project that is in either one of those. The pilot project is intended to be a relatively small injection and onshore so that it can be used as a demonstration plant. If any of you are aware, I think it's probably taking its lead from the CO2 CRC project in Australia. CCS is, if I go back to the idea of the long-term adaptation, the long-term mitigation strategy, my point was that CCS is embedded in national climate change policy. The most specific iteration we have of that is the white paper. Sorry, that should be 2011, I see. The white paper on national climate change response. CCS is named as one of South Africa's near-term priority flagship programs, and it is driven by the Department of Energy. However, if you're sensitive to the various dynamics that come into play in a CCS project, you will be aware that it's likely that a number of different role players within government will need to be a part of this. The South African government is aware of this, and so an interdepartmental task team on CCS was established some time ago, which encompasses a range of government departments, all of which are likely to have some level of interest in a CCS project. So, for example, if I run through that list, it goes energy, environmental affairs, mineral resources, etc. The Department of Energy is the custodian of CCS in the country, but the Department of Environmental Affairs is likely to be the department from which the lion's share of the authorizations that will likely be required will have to be obtained. So those authorizations range from a generic environmental authorization, possibly to a waste management license, quite likely to a water use license. So you will understand where the level of interest comes in. National Treasury is an obvious one, given the cost anticipated for project implementation. The black stripe at the bottom of the screen just summarizes what is called the South African CCS roadmap. So starting as far back as 2004. 2004 was the first iteration of climate change policy in the country. September 2004 is the first time we see a policy document that is specifically called South Africa's climate change strategy. And this roadmap runs until approximately 2025, although it must be admitted that that time frame has shifted slightly, particularly if one takes into account that central block, which is the test injection. It seems more likely now that the test injection will be commencing in approximately 2017 or 2018. But what you do get from this roadmap is the sense of a phased and stepped program that is looking towards commercial scale CCS before 2030. That ties in very closely with the pledge, if you like, the ambition that has been stated by the country to the United Nations Framework Convention on Climate Change around reducing its greenhouse gas emissions by certain volumes over certain periods. I can give you some sense of that if you would like as well. There have been in this country 5 pieces of legal work done on CCS. I've been fortunate to have led the work on the first 4 and had secured the 5th piece of work, at which point I left the firm that I was previously working for and came to ENS Africa. So the point here as well is that over a period of time, and fairly typically funded by international donors, a range of work has been done in the country looking specifically at the legal issues that would underpin CCS projects. All of these documents are available out there on the internet, and if you're looking at doing some research or you're interested in how the thinking has developed over time, these are your base documents. The most important one for present purposes is that very last one, that CCS Legal and Regulatory Framework study, which was concluded last year and which has thrown up 4 distinct options for CCS in the country. And this is where I'm going to tail off fractionally, but I'd be very curious to have conversation around these. So the 4 options for CCS regulation in South Africa are to regulate projects in terms of the Waste Act. If there are any technical people out there, I suspect some of you are frowning to yourselves and going, why would you do it in terms of waste legislation? And the simple answer is that in South Africa, the unamended Waste Act, the definition in the unamended Waste Act is sufficiently broad to include CO2 for CCS, even if it has been sufficiently cleaned. We've had a number of debates around whether the South African waste legislation deals with the idea of a waste that becomes a commodity, or alternatively a substance that falls in and out of the waste stream. While there are those ideas nascent within the waste legislation, they have not been activated. And so as we sit at the moment, it is very likely that CO2 for the purposes of CCS in South Africa will be considered to be a waste, and if that is the case, then the waste regime clearly will apply. The second option is to regulate CCS using the environmental impact assessment regime. By the way, these are not necessarily mutually exclusive from one another. They quite likely could tie together. So the EIA regime in the country, the way that currently works is that there are a series of specified activities for which an environmental authorization is required. And in order to obtain that environmental authorization, one must conduct an environmental impact assessment process. The way that CCS could be brought into this regime very simply would be to amend the list of activities for which an environmental assessment is required to include CCS. There is only one piece of legislation in this country that seeks specifically to regulate the subsurface environment. And that is the overarching mining legislation, which is called the Mineral and Petroleum Resources Development Act. There is some debate as to whether the NPRDA would in fact be appropriate, because apart from anything, the NPRDA deals with the extraction of naturally occurring minerals, and it doesn't necessarily regulate the injection of CO2 into the subsurface environment. However, it is certainly something that needs to be considered. And then the fourth option would be to develop standalone legislation dedicated to CCS. If you're a policymaker and you've understood, if you've been aware of the slide I spoke to earlier, which gave an indication of the number of government departments that might have interest in CCS, you will see a possible difficulty with devising standalone legislation, because the question is, well, which government department will administer this? In the South African context, I could anticipate that there would be a push both from environment and from the energy department to be the primary regulator of these activities. So where do we stand now? We're on the verge of moving forward for what is called the Pilot CO2 Storage Project, the PCSP. There are 3 phases for the PCSP: exploration, development, and operational. It certainly seems very clear that the exploration phase can be done in terms of the existing legal and regulatory regime, and it's possible that the developmental stage, which is the build stage, could be done, although there is some question about that. At the moment, though, it seems that the operational phase is unlikely to be entirely regulated by the existing law. So that goes back to the idea of legal studies that seek to identify gaps in the regulatory regime. This is a gap that has been identified. And indeed, if the country wants to go ahead and do the pilot project by 2016 or 2017, then some sort of regime is going to have to come into operation to deal with this project. As I said earlier, the SACS, the Center for CCS, which is the custodian of this particular project and driving the project, is considering options in both the Zululand and Outeniqua basins for the location. I'm not going to run through this in any great detail, but the reason CCS is particularly engaging from a lawyer's perspective is that the range of legal questions that pertain to a particular project are myriad. So I'm assuming you will at some point have understood that one can divide a CCS project into a range of different phases. So, for example, the capture phase, the injection phase, there might well be a transport phase in that process, post closure, and the long-term sort of liability phase, if you like. Now, each one of those phases, from a legal perspective, raises its own specific questions, and so I thought that a list of the trigger points, of some of the trigger points, if you like, for issues around law would be useful. So, for example, and allow me to perhaps enter into this one very briefly. In South African legislation, as I am sure in most legislation around the world, substances such as solid, liquid, and gases are controlled by legislation. But the phase of matter in which CO2 for the purpose of injection is likely to be is supercritical. So the question is, and you will forgive the relatively simplistic legal thinking here, the question is a supercritical substance actually regulated by a legal regime that deals only with solid, liquid, and gas? And it's that sort of question that needs to be grappled with. If I go to the very last bullet as well, the question of long-term liability becomes particularly interesting, and it is unsurprising to understand that in South Africa a lot of the solutions around long-term liability are very similar to those that we are seeing used in other countries around CCS. So the idea ultimately of the passing of responsibility for such a project to the state, as long as there or in the presence of well-considered funding arrangements. Now that set of ideas is present currently in the mining legislation, so miners are required at the commencement of their mining operations to make financial provision for closure, and so there is certainly precedent for that sort of idea in the South African law. And then I thought I would just throw two slides out that gives you a sense of how CCS comes to ground in the South African law. So CO2 is regarded as a Class 2 dangerous good in terms of a particular South African national standard, and the consequences of that are that there is a range of legal and regulatory rules that apply to how that substance, how that gas is dealt with. So if one is devising a regime for CCS, then looking at the substance to be sequestered is perhaps one of the ways to start understanding how that regime works. And then virtually finally is the question of the MPRDA and its definition of mineral. So substance naturally occurring, formed by a geological process, underground, and the idea of regulating how that substance is extracted rather than how one would insert something into the earth. Last slide are just 3 questions that Craig posed and dealt with. I'm very happy to speak to these, but I thought it might be worthwhile now for me to hand over to the tutorial guiders, and we can facilitate a discussion, perhaps referring to these questions or perhaps dealing with the questions as they arise. So thank you very much, and I look forward to the discussion.
Thank you, Andrew. Great talk. We have several questions, and Tam and I are going to take turns presenting them. If anybody in the audience wants to send in additional questions, I would encourage you to do so in the next 5 to 10 minutes to make sure that we can make sure they get addressed. First question, Andrew, is on the energy mix. You had alluded to the idea that you would like to comment a little bit more about what the potential for South Africa to transition to renewable energy sources and other non-coal energy sources, and what are some of the politics surrounding this, as well as the push for CCS.
Right, should I do that now?
Yeah, please go ahead.
Perfect. All right, so wow, wonderful. Textured and very interesting. All right, so a couple of interesting things. There is a 1998 white paper on power generation in the country, which specifies that 30% of the national grid should be devoted to renewable energy. It doesn't give a time frame, but it does indicate that this, in 1998, so please bear in mind where we are now, that this is a national priority. While about 40%, sorry, it's not quite so 40%, I could go back and refer to my slides. If you think of my slides, you will still understand, of course, that a very, very high proportion of the national grid is still coal and is still held very firmly by Eskom. Now, I'm going to say a few things now just to give you a flavor of the debate that's going on, but I express absolutely no view on the veracity of some of these things. While there has been development, very slow development towards a feed-in tariff system, power generation in the country is still held very firmly within the hands of Eskom as a parastatal. What that has led to is what appears, and forgive me now, those of you who are lawyers are going to start smiling because I'm going to start choosing my words very carefully now. What that has led to is an apparent miscalculation of the demand for power as the economy has grown and as we moved into the 21st century. So most specifically in 2008, we had a whole series of so-called rolling blackouts, which effectively was a planned process of what Eskom calls load shedding. So in simple terms, turning parts of the grid off at particular times with a warning to people, sometimes with no warning to people, in order to stabilize the grid. Although we were promised that would not happen again, it actually has begun again very recently. So in a really quite sophisticated economy with very large-scale power draws on the grid, we are now in a situation where the national utility is asking people well, I mean, to work more efficiently, that's absolutely fine. Perhaps I'll put it this way, they're warning people that the grid is going to be turned off in certain instances. At the same time, the feed-in tariff program is developing apace, and a number of projects have been approved for feed-in tariffs over a number of different renewable energies. The standard ones are there: wind, solar. If you know anything about this country, you'll know that probably we've got among one of the best solar resources in the world. However, I recently read a very acutely argued opinion piece that effectively argued from the perspective that Eskom would only very, very reluctantly ever give up its control of the grid for a number of vested interests. So it remains to be seen just how quick the uptake of renewable energy is. You will appreciate there's been a lot of investment in renewable energy. There are a number of industry associations. I, for example, sit on the policy working group of the Wind Energy Association, but there are industry associations for all of the renewable energies available in the country. And so consequently, there is a very strong lobby behind renewable energy. Juxtapose that, and this is my last comment, juxtapose that with what I said about the volume of the Waterberg coal resource, and the fact that there is a very strong view within Eskom that base load can never be generated by renewable energy. The base load will always have to be fossil fuel generated. So those are some of the dynamics that are at play. It's certainly never a boring environment to do business in. Is that sufficiently useful, Craig?
Andrew?
Yes, hi?
Yes, thank you. That's great. I'm going to turn it over to Pam, who's got a question on pilots.
Right?
Yeah, Andrew, for the second question, we have a question here on the pilot project. So you
Yes.
gave a timeline for development of a pilot project with commercialization by 2030. Have concrete steps have been taken towards selecting a CO2 source? Can you comment a little bit more on the pilot project developments? And
Sure.
then do you see any other pilot developments in other sub-Saharan African states?
So that last one's an interesting one. I'll talk to that and certainly be able to talk to that. Yes, there have been a number of very concrete developments around the pilot. Bear in mind that the Center for CCS, its primary objective is to implement that pilot. And so among the actions that it has taken have been the legal and regulatory work that I've mentioned, but also the things that I haven't mentioned is that there have been a number of technical studies, geological studies, economic studies that have been undertaken. The question on the source of CO2 is a very interesting one. You may or may not be aware that the purest source of industrial CO2 in the world is generated by Sasol in this country. Now, Sasol's main business is as a petrochemical company, but it runs a process, I suspect people will be aware, in terms of which it creates fossil fuel from coal. Among its processes is a very pure, 98% pure stream of CO2, which, and you will forgive me now, this is the lawyer speaking, as much as I understand is that with very little cleaning, that stream of CO2 would be appropriate for the pilot project. The difficulty with that is the fact that Sasol has its own vested interests in various of these processes, and it is not necessarily a foregone conclusion that Sasol will simply hand over its pure source of CO2 for use in the pilot project. There have been some discussions, including the idea of purchasing some of that CO2 from Sasol for the purpose of the pilot project, which kind of feels a bit counterintuitive, but nonetheless. The other alternatives would be to capture, clean, and then transport to the coast emissions from one or other of the large Eskom coal-fired power stations. I suspect that would bring a large cost to the pilot project that is not currently being anticipated. I think the idea behind the pilot project primarily is to access a readily available stream of CO2 and to use that simply for the purposes of demonstration. Mm-hmm. So a number of steps have been taken. As I said, they are about to commence the exploration phase, and what that means is using the data in the atlas is to do specific ground truthing and seismological studies for the specific purposes of identifying a site for the pilot project. And as I said, that'll either be the Outeniqua Basin or the Zululand Basin, so the southeast coast or the north coast. In terms of what might be going on elsewhere in the countries around us, remember my comment about the size of the Waterberg coal deposit? The lion's share of that deposit, literally 9 or 10 times the South African share, is sitting under Botswana. Mm-hmm. Botswana is currently doing a set of studies very similar to where South Africa was 2 years ago. So I wouldn't be surprised. Well, I mean, it's very clear that it is very firmly on their agenda, and there are two very interesting legal and logistical discussions that can happen around that. First of all, there's a lot of potential, as I understand it, in Mozambique for coal bed methane sequestration. So clearly the use of coal beds to sequester the CO2. The other idea is to bring that CO2 over the border into South Africa, and for South Africa, in a sense, then to become a location for the sequestering of CO2 emissions from other countries. So as a commercial venture, possibly. If you are attuned to some of the legal consequences, you will be aware that what that does is it brings in another set of international legal considerations. For example, would the Basel Convention on the Transboundary Movement of Hazardous Waste apply? So any way you look at this, it becomes increasingly more complex and interesting as we move on.
Very interesting developments in the region. I guess something to keep an eye on for sure. I think Craig may have lost audio. Craig, are you there by chance? So I'm going to go ahead with my next question, Andrew. Sure. From your perspective, what should be the best approach in terms of regulations and financial, both government and private sector structures to develop future CCS projects in countries such as Colombia with few emissions and relatively clean energy matrix? Should a country like this actually develop CCS projects?
I'm not sure I'm the best person to answer that. That sounds like a kind of a technical economic question. But I'll give you a perspective, and perhaps I'll do it by answering the question back again. Is the potential volume of CO2 to be sequestered in this manner in a country like Colombia, would it justify the expense, the cost that it would take to set up one of the projects and get it moving? For example, we're in the South African context, and I'm not talking about the pilot project because, of course, the intention of the pilot project is that it is funded and it goes ahead, notwithstanding the commercial reality. But I've heard figures bandied about for the need of a carbon price per ton of CO2e of something between $50 and $70. The cost of sequestering CO2 in South Africa. Now, at the moment, in the current scenario where we are only taking tentative steps to cost CO2 in the country, or greenhouse gas emissions in the country, that is completely out of the question. So there have to be other dynamics that come into play. And I watch this space with great interest. So effectively, I've turned the question around. and perhaps then the high-level comments that come out of this is that this is a very expensive and very difficult process. Are there not better ways to sequester a relatively small level of emissions in a country like Colombia than CCS? I'll leave it at that.
Yeah, that's a good way to turn it around, Andrew. I think a good way to take a look at things. Craig, are you back with us?
I am, yes. Some minor technical difficulties, but they're overcome. Andrew, I think we have time for maybe one or two more questions on domestic issues. You presented a slide for the World Bank's conclusions showing 4 regulatory options, and among those, does any of the existing legislation cover risk assessment? What kinds of approaches are being considered in South Africa for risk assessment? Then a second question on domestic, which is really a bit international, is for geologic storage shared with some of the neighboring countries, as well as Lesotho. What kinds of transboundary legal issues do you expect to see in South Africa?
Great. All right, good. Two good questions. Again, thank you. Let's go with the first one. So from a risk assessment perspective, preliminary comment, it might be worthwhile pointing out that although the World Bank study, the options that come out of the World Bank study seem to present 4 separate options, the reality of the matter is that the way legislation in any country works is that if the legislation applies to a particular activity, whether a specific regime applies for that activity as well, there will be another layer of legislation that applies. So let me be clear. If we say, for example, devise a standalone CCS regime in the country, unless that regime very deliberately, and in my view quite unlikely scenario, but unless that regime very deliberately excludes the application of other environmental law, then that environmental law will apply. And so that environmental law, for example, would be issues, the law relating to environmental impact assessment, or issues around waste or water. Now, if I hone in on the question of risk, there is a very clear regime that deals with risk assessment in the country, and that is the legal regime pertaining to environmental impact assessment. So the first legal regime around EIA appeared in the country, became operational in the country from the beginning of 1999. It has been amended 3 times since then, and it has become increasingly complex. Among the considerations that must be dealt with in an environmental assessment process are alternatives to the proposed project activity, the no-go option, risks associated with the project, and how to mitigate those risks. What does that mean? It means that I anticipate an EIA undertaken for a CCS project is going to be fraught with difficulty, simply because when it is done for the first time, it will be the early mover in the country, and consequently there are going to be a number of issues that the regulators are going to be reticent to deal with. And I make that statement as a practitioner in this jurisdiction who has been dealing with infrastructure projects for more than a decade. When you are dealing with a unique project or the first mover of its kind, the regulators become a little bit tetchy. And so I anticipate that sort of difficulty, but there is very definitely a regime that, and a quite well elaborated regime that will deal with risk. If I look at the question of transboundary, yes, as I said, I mean, I alluded to the fact that if you're going to do transboundary movement of CO2 in the SADC region, which is the Southern African Development Community, if you're going to move CO2 in a transboundary manner in SADC, you are very likely going to trigger international conventions like Basel. But bear in mind, there are a number of SADC protocols that themselves regulate the relationships between the countries in the region, including regulating, for example, the use of water courses and so forth, and indeed also regulating movement of wastes and so forth. So what you are doing in that level, if you are seeking to implement, call it a transboundary CCS project, you are layering in another set of legal considerations that have the potential to both promote and upset that project. What that means is that you've got to plan very, very carefully for how you deal with that law in your project. Bear in mind, it's unlikely that these sort of considerations will apply to the pilot project or the next phase of the pilot project, which is called the demonstration project. So they're talking pilot project, tens of thousands of tons, perhaps 40 in terms of sequestration. Demonstration project, hundreds of thousands, and then full commercial utilization by the end of the year. By the end of 2030. What I would anticipate, though, if we did do industrial scale or commercial scale CCS transboundary projects or a project in the SADC region, is that there would be a specific protocol dedicated to dealing with it. And the reason I say that is because I think it has such unique characteristics that you would need to carve it out and deal with it in a very specific manner. If it's not a SADC-wide protocol, then I have absolutely no doubt that it would be some sort of bilateral or perhaps wider multilateral agreement between the countries in the region to whom that applied.
Mm-hmm.
Thank you, Andrew.
Thank you very much.
That is the balance of the questions. I would like to thank you, Andrew, for giving the presentation. Excellent overview on CCS status and prospects in South Africa. If anybody has other questions about this presentation or any of the other presentations, questions can be submitted through the intranet. Recordings of this webinar and the presentation slides will be available on the website in the coming days. I'd like to remind you that we will post quiz questions on the intranet after this session, and model answers will also be posted in several days. Again, it's a good opportunity to test your own knowledge about the presentation. I'd like to thank Andrew once again and the Institute for the opportunity to present on the Junior Professional CCS Network. Thank you everyone for participating. And Pam, would you like to say a few words?
Just again, thank you, Andrew. Jess, thanks for your organization and leadership, and Kylie, who works behind the scenes to make this happen. Again, please reach out. Craig and I, we want to see you succeed. We're here to help you build your network. If you have questions on topical areas, or if you'd like us to connect you with anyone in our networks, we're happy to do that. Just a quick commercial on the REX program. It will be held this year on June 1st through the 10th in Alabama. It's sponsored by the U.S. Department of Energy with support from the CCS Research Coordination Network and the Global CCS Institute. We're going to take 30 participants. However, only 5 to 10 of them will be from outside the U.S. And we'll open up the applications later this week, which will be open until about May 1st. So I encourage you to check out the website, www.recsco2.org. Again, thanks so much for your participation in this webinar. Please stay in touch, and this concludes the Global CCS Institute's legal and regulatory tutorial for this evening and this session. Thank you very much.